talk about kind of the Supreme Court rulings that are happening at the federal level this week. Kind of specifically, we can start with the independent state legislature theory. Talk about what kind of happened with that and how that can trickle down into Iowa and impact Iowans.
The United States Supreme Court decided Moore versus Harper this week, a very important opinion dealing with election law. In order to understand Moore versus Harper, we need to be aware of, I think, two fundamental principles. First, gerrymandering, or the drawing of election districts for partisan purposes, has grown in recent years. And it's grown, I think, for two reasons. One, of course, we have party polarization. But secondly, with all of our technology and computer-based data analysis, the legislatures of both political parties are capable of drawing maps that tend to favor incumbent based on a partisan basis. So this is thought to be a real threat to democracy if elected officials can kind of cement their positions notwithstanding the popular will. The United States Supreme Court, in a case called Rucco in 2019, declared that it would not intervene in partisan gerrymandering cases under the United States Constitution. But that left state courts open, at least, to regulate partisan gerrymandering under state constitutions. The United States Supreme Court, of course, is the ultimate arbiter of federal constitutional issues, and so it's declared the federal courts are out of partisan gerrymandering. But state Supreme Courts are generally thought to be the ultimate arbiter of state constitutional provision. So in Moore v. Harper, there were two cases, one from Delaware, where the Democrats were engaged Maryland, where the Democrats were engaged in partisan gerrymandering, and the other was North Carolina, where the Republicans. So it was balanced in terms of party. And in those cases, state Supreme Courts, under state constitutional provisions, invalidated legislatively approved redistricting plans that were designed to favor one particular political party over another. The question in Moore versus Harper was whether the federal Constitution would permit states to engage in this kind of regulation. And the key part of the United States Constitution was Article 1, Section 4, Clause 1, which basically says time, place, and manner will be prescribed by the legislature of each state. And the question was, well, it says the legislature of each state. It says nothing about courts. It says nothing about gubernatorial vetoes. And so the claim was made that the legislature is independent of its court system, independent of the governor. The legislature means the legislature. So once a map is drawn by the legislature, state courts cannot intervene. If this theory had been embraced by the United States Supreme Court, hundreds of state constitutional law provisions would have been struck down, hundreds of cases overturned, and lots of delegation of power to election commissioners in states would have been invalid. But the Supreme Court, 6-3, held that ordinary judicial review by state Supreme Courts was consistent with the federal Constitution. The general proposition coming out of Moore is that state Supreme Courts may, under state constitutional provisions, review partisan gerrymandering for compliance with state constitutional provisions.
I guess my next question for you with that, it has to do with independent state legislature ruling, but also kind of has to do with the Supreme Court ruling on, the Iowa Supreme Court ruling on abortion from a few weeks ago. So obviously that ruling was different from what federal ruling says. So I guess, do you agree that the Iowa Supreme Court holds independent authority to interpret the state law? And if so, how should they respond and incorporate the U.S. Supreme Court rulings into their own decisions?
Well, as a general matter,
generally, yeah.
As a general matter, the Iowa Supreme Court is the ultimate decider of state constitutional law issues. They can look to federal law for guidance, the United States Supreme Court guidance for guidance. They can look to the Supreme Court of Minnesota for guidance. They can look to Associate District Court in Kentucky for guidance. But I think all commentators would agree that, at least in Iowa, that the Iowa Supreme Court has independent authority. There may be some desire on part of members of the court to defer to federal authority based on some notion of uniformity. That as a matter of state constitutional law, uniformity is important. But of course, we have 50 states and 50 independent constitutions, and so diversity was kind of baked into the cake when our country was formed at the very beginning.
Yeah, definitely. And going back to the independent state legislature theory, since Iowa is a very politically active state, could the Iowa Supreme Court rule something differently, or maybe want to, obviously, like you said, they have the right to make their own independent decisions.
Right.
So what do you think the next steps could look like for
Well, let me describe the Iowa landscape. First, as you know, the United States Supreme Court in the 1960s and 70s developed a body of case law regarding one person, one vote. And Iowa passed a constitutional amendment to its state constitution, Article 3, Sections 34, 35, and 36, which basically set up a procedure for challenges to legislative reapportionment. Those constitutional provisions specifically allow an elector to challenge a reapportionment plan before the Iowa Supreme Court, and the Iowa Supreme Court is giving authority to review the plan for compliance with the Constitution. Now that's very interesting because there's really two constitutions. There's a federal constitution, a state constitution. Our case law, though, suggests that Iowa constitutional provisions are included within the term, the Constitution. So, unlike the federal constitution, the state constitution in Iowa has a specific procedure for review of reapportionment plans by the Iowa Supreme Court. And then a second feature I want to share with you is that Iowa has enacted a statutory scheme to deal with reapportionment in Chapter 42 of the Iowa Code. And this state statute has been in existence since 1980, and it provides a process for the Iowa Legislative Services Agency to develop the first draft reapportionment plan for submission to the legislature. The legislature then votes it either up or down, doesn't amend it. If the legislature rejects the first plan, a second plan is drafted. If the legislature rejects the second plan, a third plan is drafted. At that stage, the third plan is open to amendment, and the legislature could, in theory at least, go off on its own. In the 5 decades since 1980, each time the legislature has accepted one of the plans drawn by the Legislative Services Agency, which is directed to draft the plan on a nonpartisan basis. Chapter 42 has a list of conditions. One of the conditions is that partisan politics not be involved in the drafting of the plan. So the bottom line is Iowa, through this statute, has had nonpartisan reapportionment for the last 50 years. It seems to me it served Iowa quite well. What does Moore versus Harper say to the Iowa Supreme Court? Well, there is no federal obstacle for the Iowa Supreme Court to engage in the power of ordinary judicial review of any kind of reapportionment plan in the state of Iowa. Now, how the Iowa Supreme Court interprets the Iowa Constitution is a matter generally for the Iowa Supreme Court. I got to tell you, there's one tricky exception, and that is the Chief Justice Roberts, who did the Moore versus Harper case, talked about ordinary judicial review, and I put it in quotes. And the suggestion is, well, maybe if the state Supreme Court was way off the reservation in interpreting a state constitutional provision. In other words, interpreting a constitutional provision to evade federal law, then maybe the Supreme Court would step in. And this language has caused consternation, I can tell you, in the scholarly community. I mean, some say, oh, well, it doesn't really mean that much. And others say, oh, the door is kind of open. And that's going to wait another day. But I think it's fair to say, on balance, that conventional judicial review of partisan gerrymandering under state constitutions will generally be permitted, notwithstanding Article 1, Section 4, Clause 1, that says time, place, and manner by the legislature.
Okay. Yeah, no, that was really helpful information. Thank you for explaining that and breaking that down for me generally with the Iowa Supreme Court.
Sure.
So I guess another kind of general question, just with the week of Supreme Court rulings, what impact can all of these have on Iowa, previewing all them and the ones that have already happened? And what are some of the next steps that the Iowa Supreme Court could take generally?
Okay, well, let's start off by the notion that the United States Supreme Court is the ultimate interpreter of the United States Constitution. Those interpretations are binding on the Iowa Supreme Court for purposes of federal constitutional provisions. So, just to give an example, supposing the Supreme Court in a search and seizure case says a search of a person without a warrant violates the federal Constitution. And let's say it's a 5-4 vote. The Iowa Supreme Court is bound to follow the majority, even if they think the minority had the better argument, on the question of federal law. But on the question of state law, the opposite is true. So let's use search and seizure again. Supposing the Supreme Court says a search is valid under the Fourth Amendment. But under the Iowa Constitution, maybe the justices think differently. A good example is a recent trash case. Do you need a warrant to search a person's trash that's placed out near an alleyway, let's say? The United States Supreme Court has said no, that when you throw stuff in the trash, you basically abandon any privacy interest. That's binding federal law in Iowa, but the state Supreme Court decided that there was still a privacy interest under the state constitution. So generally we have two independent tracks. You know, one of the things that's frequently overlooked is state constitutions came before the federal constitution. We had 11 state constitutions in existence. In many of them, the principle of judicial review of state statutes was established. And the United States Constitution came later, and we have two independent lines of case law.
Okay. Yeah, so I know you're talking about those two independent lines, and generally that'll apply to all the Supreme Court decisions that are being made. So I don't have to ask specifics about the affirmative action case that happened today, but I guess a general question, but this also applies to the other ones. Do you think that if Iowa wanted to, they could take different routes that they want to, that the Supreme Court is ruling?
Well,
regarding student loans, affirmative action,
yeah.
independent state legislature, all the above.
Where the United States Supreme Court, based on the federal Constitution, says a state cannot take certain action, the Iowa Supreme Court has to salute it and say, that's right. Where the United States Supreme Court, based on federal law, declines to offer protection, as in partisan gerrymandering, but a state wants to go further under its state constitution, it may. So it depends on the nature of the federal case. But if the federal government holds up a stop sign and says, stop, you cannot do this under the federal constitution, the Iowa Supreme Court must follow that mandate.
Okay, so what I'm hearing is what the U.S. Supreme Court says, the federal constitution, that's set. However, if Iowa wanted to go even further, they have the right to.
Right. I mean, again, it depends upon what exactly the United States Supreme Court opinion does. If the United States Supreme Court prohibits government from taking certain action, under the United States Constitution says you can't do that, then the Iowa Supreme Court must follow it. If, on the other hand, the United States Supreme Court issues a decision that declines to prohibit certain action, like they declined to intervene in partisan gerrymandering, the state Supreme Court, under the state constitution, may provide greater protection because it doesn't conflict with the federal law.
Definitely. And I know you said you haven't read the affirmative action case, but just since it's so timely, nothing specific about what was ruled, but I guess going up to it, are you able to share with me kind of your thoughts from a Supreme Court justice perspective about how to go about this for colleges? Because you're also a college professor.
Every law school, every admissions office is going to review the decision of the United States Supreme Court with great care and determine what is permitted and what is not permitted. To the extent the United States Supreme Court has declared that certain types of activities are not permitted under the United States Constitution, that will be binding on public universities, on states, state schools.
So what impact do you think that this would have?
Well, that of course remains to be seen.
Correct, of course. Okay, and then so previewing the student loan decision, because that's obviously another big decision that is coming up. Looking at that from a former Supreme Court justice, what do you kind of see going into that decision, and how that will impact people, and if you think that's something that, again, would leave open for state interpretation?
The student loan case involves a larger principle. And the larger principle is, to what extent may Congress delegate policy-making power to agencies, to the president, to outside of Congress. So there's no express statute expressly stating that the president may forgive all student loans. The statute in part suggests that the terms might be modified. And the question is, what's the scope of a term? If a term being modified, is that forgiveness? But the fundamental question in this case is, to what extent may Congress delegate its authority to others? The concept coming out of the New Deal was that Congress could delegate quite a bit. And I would say after the New Deal, the law tended to permit delegations of power. There was some deference. There was a doctrine called the Chevron doctrine, where the courts gave some deference to agency interpretation of the law. But the current Supreme Court is re-examining, I think, some of those decisions, and as a general matter, is looking into whether Congress has to be more specific in the delegation of its authority. A vague delegation of authority on an important question, the Supreme Court might be skeptical whether Congress intended to delegate it at all. Whereas in the past, I think some courts, including the United States Supreme Court, has been more generous in those interpretations. Now, for the Iowa Supreme Court, the question might be, under the Iowa Constitution, to what extent can the General Assembly delegate power to state agencies, environmental protection, Department of Revenue, etc. And the Iowa Supreme Court is free to develop its own delegation doctrine under the state constitution.
Definitely, and you've done a phenomenal job of explaining kind of the differences between Iowa Supreme Court and federal Supreme Court, excuse me, and really appreciate that. Are you able to kind of just do a breakdown for people that may not exactly understand all the legal terms, do a breakdown of what this week at the U.S. Supreme Court means for state Supreme Courts and just, I guess, people in Iowa in general?
Well, the United States Supreme Court plays a very important role in our system of government, of course, as do state Supreme Courts. And so lawyers all across the country, lawyers in public practice, lawyers in private practice will be examining the cases. Of course, the holdings in the cases are precedent. They don't answer every question, and lawyers rightfully will be trying to see what the boundaries are to try and maybe evade a prohibition, or escape might be a better term. But no question, these decisions have real world impact. Going back to Moore versus Harper, if the independent legislature theory had been adopted, the Iowa constitutional amendment that I spoke about would be invalid. Chapter 42 may or may not be valid. Delegation of authority to elections commissioners would have been in doubt. That would have had dramatic consequences. And certainly the affirmative action holding will have consequences. As I say, what they are remains to be determined. But in this country, we believe in the rule of law and following authoritative precedent. And so the real world impacts will certainly be there. Student loans, affirmative action, civil rights, etc.
Correct, thank you. That was an amazing explanation. Wow. No, I really appreciate that. It's just easier for it to have like that legal expert explain it, break it down a little bit. I do kind of want to go revisit the Moore v. Harper, if you don't mind.
Yeah, sure.
And I'd love to talk kind of a little bit more and kind of pull that apart.
Yeah.
Just to, what impact could that have had on the states? Because obviously that was a big theory that would have had a major impact. So can you talk about what that would have looked like and what it means that that theory wasn't adopted?
Well, first, the reapportionment plans in Moore versus Harper were quite extreme. Quite extreme. In North Carolina, there was testimony that the plan that was adopted was 99.999% outlier kind of thing.
Do you remember your hand off the mic?
Oh, I'm sorry.
No, you're good. You're good. I just wanted to make sure it wasn't. Sorry.
And had the decision gone the other way, it would have been an absolute green light to really, what I think everyone would agree, including the dissenters, by the way, everyone would agree, is a egregious partisan reapportionment plan. And so I think the consequences of that kind of ruling would have been very negative. The decision also probably has substantial impact on presidential elections as well. Article 1, Section 4, Clause 1, deals only with congressional elections. Article 2, Clause 2, has a similar provision with respect to the selection of presidential electors, which will be by the legislature. Does the legislature have independent authority to select electors for president, or is it subject to judicial review? And the logic, certainly, of Moore versus Harper is that the independent state legislature theory would apply to Article 2 as well as Article 1. And so that means that legislators cannot overrule, if you will, kind of meet in special session and overrule the results of a presidential election simply because they're the legislature. It seems to me that would be a destabilizing rule of law too if it had been adopted.
Definitely, and you talk about how it is a pretty egregious theory that was being talked about. Why do you think it did get to the point where the Supreme Court was reviewing this, if it is so extreme?
Well, I don't know if I characterize it extreme. It is a textual interpretation. You look at the term "the legislature," and you kind of say, well, the legislature means the legislature. It doesn't say anything else. But if you look at the history and the context of the provision, it's certainly the Supreme Court majority held. It wasn't designed to oust what it called ordinary judicial review. But it was a textualist kind of interpretation. The Supreme Court, by the way, had rejected that theory a couple times earlier in unanimous decisions. But it had been raised by litigants, and certainly, you know, on the reapportionment issue. Reapportionment, there's many cases challenging reapportionment plans, dozens. Now, some of them are racial discrimination, and some of them are one person, one vote, and some of them are partisan gerrymandering. But it's a big deal in terms of our election process.
Definitely. And I know, I guess, I kind of want to open it up to you. What are some things that you do want to share about that independent state legislature theory, what it means now, that it wasn't adopted, or maybe kind of the process of going through that and looking through that, if you wanted to?
Well, I think what the rejection of the independent legislature theory means is that state Supreme Courts, under state constitutional provisions, may engage in judicial review of allegedly gerrymandered maps based on partisanship. What standards they apply to determine whether it's impermissible or not is up to the state Supreme Courts. Conceivably, some states, and indeed this has happened, some state Supreme Courts have said that, well, just like the federal courts aren't reviewing partisan gerrymandering, the state Supreme Court doesn't want to review partisan gerrymandering. It's a political question. It's too hot. There's no judicially manageable standards, is what's usually stated. So a state Supreme Court still has the ability to exercise its independent power to say, we're not getting involved either. But a number of state Supreme Courts have, and that there will not be an obstacle under Article 1, Section 4, Clause 1 to that activity.
Awesome, thank you. Is there anything else that you think I'm forgetting to ask, or that you think is essential knowledge? I know it's a big question.
Well, let me think.
It's a big question. Yeah, take your time. And even just regarding this, just Supreme Court rulings in general, I guess, that you think would be good information to know.
Well, I think we covered quite a bit, actually.
We did. No, I really do appreciate your time. I've learned a lot, and I'm fascinated by it.
Well, you're gonna have an editing challenge, I think, maybe, but.
I know, I want to put it all in there. So I guess generally, I really want to be able to kind of do a general story about the Supreme Court rulings that are happening all throughout the week. Do you mind if I use your general comments about looking at the ruling and how that goes into the Iowa Supreme Court?
No, that's okay.
Okay, awesome, thank you. And
no,
then
that's okay.
obviously we talked plenty about Moore v. Harper,
Yeah.
which I appreciate.
Yeah.
Because that's something that I was really interested in and learning from you about. So I mean, I guess I don't think I have any other questions unless you have any further comments or anything, maybe just about this week's impact, I guess, locally, if there is anything.
Well, the impacts are somewhat obvious. I mean, when the student loan case comes down, the impact locally is going to be pretty clear. Either some people are going to get relief or they're not. And the impacts of affirmative action actually are a little less clear, I think, because nobody knows. You know, people will study that opinion and try and figure out, well, what can they do? What's permissible? What's not permissible? And what the ultimate impact will be remains to be seen, I suspect. And the Moore v. Harper, I think we've gone into some detail. So